Welcome to The Explainer. For any legal practitioner in Australia, there are few things more dangerous, more high stakes than identification evidence. It's an area of law where a simple mistake can lead to, well, a total disaster. So today, we're going to dig into why that is and look at the critical safeguards the system has put in place to stop those catastrophic errors from happening. So here's what we'll cover. We'll kick off with the identification crisis, then get into the psychology of why our own eyes can fool us. After that, we'll walk through the legal solutions, from police rules and crucial judges' warnings all the way to the evidence acts we use today. All right, let's dive right in. And to really get why this area of law needs so much care, we've got to go back in time to a case that literally shook the justice system to its core. So this is Adolf Beck. Back in the late 1800s, he found himself accused of a whole string of frauds. Now, the evidence against him, it looked absolutely rock solid. I mean, get this. 11 different women picked him out of properly run police lineups. 11! You can imagine the case felt like a slam dunk. Beck was convicted, and off to prison he went. There's just one problem. He was completely innocent. The real guy was caught years down the track, and Beck was finally pardoned. Now, his case, and another one just like it, involving a man named Oscar Slater, just sent absolute shockwaves through the legal community. It was a terrifying wake-up call. Eyewitness testimony, even when you've got multiple, totally confident witnesses, can be just devastatingly wrong. These miscarriages of justice were so profound, they're the reason the English Court of Criminal Appeal was created in the first place.
So what is going on here? What's the root of the problem? The scary part isn't that witnesses are lying. Not at all. The real danger, the one that keeps lawyers and judges up at night, comes from honest, genuinely convinced people who are just tragically wrong. And it all comes down to the pretty surprising and fragile way our brains actually handle what we see.
Think of a solid, reliable identification like a mental chain with 5 links. Okay, so first you got the observation itself. Then, that observation has to get imprinted on the mind. Step 3, your brain has to hold on to that original impression. And here's the kicker, step 4, that impression has to stay pure. It can't be changed by anything from the outside. Only if all that happens can you make a real judgment of identity and not just say, oh, he kinda looks like the guy. The thing is, if even one of those links breaks, the whole chain falls apart. And believe me, the potential for things to go wrong here is just huge. Maybe the observation was just a quick glance in a dark alley. We all know memory fades over time. Then you have this massive danger called the displacement effect. That's where a witness's brain just swaps out their own fuzzy memory for a nice, clear police photo they were shown. On top of that, you've got the well-known difficulties with cross-race identification, throw in a witness who's super confident they're right, maybe some suggestive police procedures, and boom. You've got a perfect storm for a wrongful conviction. So with all these dangers, what does the law do about it? Well, the very first line of defense starts with the police. It's all about having strict rules for how they handle identifications from the get-go.
Yeah, the law is really, really clear on this. There's a huge difference between good and bad ID procedures. The absolute gold standard? That's the identification parade. Where the suspect is put in a lineup with a bunch of other people who look similar. It's a real test of the witness's memory. And then you have the other end of the scale, the doc identification. That's when a prosecutor points to the accused in court and asks, is that the man? It's just so incredibly suggestive and is considered pretty much worthless as evidence. Why? Because the whole situation is basically screaming, hey, look, this is the guy we already arrested.
Now, when the police start using photos, a couple of major red flags pop up. The first one is something called the rogues gallery effect. Think about it. If a jury hears that the cops had a photo of the accused on file already, what are they going to think? They're going to assume the person has a criminal record, right? And that's classic prejudicial evidence. It makes the jury think about guilt based on past behavior, not on the actual facts of the case in front of them. And the second big danger with photos is that displacement effect we mentioned earlier. This is a really crucial psychological trap. So a witness sees a clear photo of a suspect. Their brain, without them even realizing it, can grab onto that sharp, perfect image and just overwrite their own probably messy and incomplete memory from the actual crime scene.
After that happens, the witness isn't really identifying the person they saw commit the crime. No, they're identifying the person from the photograph. Okay, so we've got the police procedures as one safeguard. But the final backstop, the ultimate firewall against a wrongful conviction, that responsibility falls squarely on the trial judge. It's a duty that is absolutely mandatory, non-negotiable, and it's known as the Domican warning. This all stems from a huge high court case, Domican against the Queen. And the court could not have been clearer. If identification evidence is a key part of the prosecution's case, the judge must warn the jury about how dangerous it can be. And we're not talking about some vague, oh, be careful, folks kind of warning. No way. The court said it has to be specific, it has to be powerful, and it has to be custom-built for the facts of that particular trial. So what does a proper Dominic warning actually involve? It's a really detailed, hands-on instruction. The judge has to start by telling the jury that history is absolutely full of cases where people were wrongly convicted because of a mistaken ID. They have to say, point blank, that a witness can be honest, totally confident, and still be wrong. But the most important part is this. The judge has to dig into the evidence from that specific trial and point out every weakness. Things like, remember, the witness only saw the person for a few seconds. Or, don't forget, this ID happened 6 months after the event. And they can't just list the problems. They have to explain why those things are weaknesses and deliver that warning with all the weight and authority of their position. All right, to wrap things up, let's see how all these crucial principles, hammered out in the common law through cases like Domican, have been locked into place in black and white legislation. I'm talking about the Uniform Evidence Acts that are used in courts right across Australia. What this legislation does is create this brilliant, layered defense system. You've got Section 114, which basically says ID parades of the default, unless there's a good reason not to hold one. Then Section 115 brings in really strict rules for using police photos, to stop that prejudice and displacement we talked about. And finally, Section 116 makes that Domican-style warning, that special need for caution, a compulsory part of the judge's job. When you put them all together, these sections form a powerful legislative shield. So you can see, for more than 100 years, the law has been trying to get better and better at dealing with the fact that human memory is, well, human. It's fallible. But here's a thought to leave you with. As we step into this new world of deepfakes and AI-generated images, are the old problems just changing shape? Are we facing a whole new, maybe even more complex version of the same old challenge? It really makes you think. The struggle to prove identity is far from over.